In this video, we'll discuss regarding the general exception to liability in torts. So, there are 5 general exceptions to liability in torts, and the first one, the maxim relating to general exception, is volenti non-fit injuria. So, volenti non-fit injuria means harm suffered voluntarily does not constitute a legal injury and therefore is not actionable. If you invite someone to your house, you consented to his entry, so you cannot sue him for trespass. In the same, if he is invited to be entertained in the drawing room but entered into your bedroom without your permission, then it is trespass and it is actionable. So, regarding the maxim volenti non-fit injuria, we would discuss 5 important leading cases, and out of those 5 leading cases relating to the very maxim volenti non-fit injuria, the first one is regarding Shadwell's versus the Imperial Chemical Industries Limited, and it was decided in 1964. Exactly, it was relating to a matter that House of Lords held that the plaintiff consented, so no question of damage arises, and it was regarding a particular query where the defendant added a statutory regulation is also there. So an explosion happened and it injured the plaintiff by testing some detonators in that query. So here the defendant could not be held liable as it was voluntarily a step taken by the plaintiff. And in the next important leading case, and that is regarding Ulrich versus Shamar in 1968, the Queen's Bench held that the plaintiff, a photographer, he voluntarily went into the horse race, and in that horse race he was injured, and as he went to the horse race to shoot some pictures of the horse race, so it was a voluntary action, so there was no question of liability of the defendant. So also in another leading case, and that was regarding Hall versus Brooklands Auto Racing Club, and that was in case of 1939, and it was held by the King's Bench that the plaintiff was hit by a car and which come off the track of that car racing. So here the plaintiff went into witness the car racing and he was injured. So here he went voluntarily to the auto racing. So if he injured, it was a voluntary action of the plaintiff. So this is not actionable under tort. So consent cannot be given to an illegal act, and that is also falls under volenti not fit injuria, and this was decided in the leading case R versus Donovan in 1934 by the King's Bench, where the plaintiff as such was fighting with naked fist, duel with sharp swords, which are unlawful. So here the plaintiff was itself participating in such a game which was held illegal. So here it would be held that he did it voluntarily, so it is not actionable. So also in another leading case, Smith versus Barker in 1891, the Court of Appeal decided that knowledge of risks is not the same as consent to the risks. So there was a stone cutting crane carrying heavy stone as no warning was given. So the defendant was held liable on the ground of knowledge of risks and voluntary acceptance of risks. Here it is the duty of the defendant to give warning regarding that particular crane which was carrying heavy stone. So automatically the plaintiff could not be assumed that he voluntarily accept the risks, even though there is the knowledge of risks, but it was the duty of the defendant to warn about the stone carrying crane of heavy stones. So these are the important 5 leading cases which could be related to the very maxim volenti non fit injuria. So from these very 5 leading cases we reached certain conclusions, and those are: number 1, consent must be freely given, and the second one, consent cannot be given to an illegal act, and number 3, knowledge of risks is not the same thing as consent to run the risk, and the next one, that is consent is free if it is obtained without undue influence, coercion, fraud, misrepresentation or mistake, etc. So these following conditions we derived out of analyzing these 5 leading cases which were decided by the Queen's Bench or the King's Bench or the Court of Appeal or by the House of Lords regarding the interpretation of the very maxim volenti non fit injuria.